right, ladies and gentlemen, we now move into the final portion of this. You've heard the arguments, counsel, and certainly they will be very helpful to you in just short order when you begin your deliberations in this trial. And each of the parties in this matter, the attorneys, the court expects that you will very shortly apply your common sense, your sense of logic and reason fairly and impartially, analyzing evidence consists of the testimony of the witnesses and exhibits that were introduced through the testimony and nothing else, and decide what you believe to be the true facts in this proceeding. When you've done that, you conscientiously consider and evaluate the evidence and then apply the law that I will give to you, that I would suggest and submit to you to the bond of your starting, and that both sides would obtain and receive a fair and impartial determination. During this instruction, I may from time to time use the word defendant. Defendant is a term we use to designate a party against whom the claim is made, and that's the sole significance of that term. It means nothing else. As I told you, he was accused in the indictment which I showed to you. That is what I showed as a piece of paper. It will not accompany the jury room. Why? Because it's not evidence. It merely contains the allegations against Mr. Moorer. And to that indictment, Mr. Moorer has rendered a plea of not guilty, which places upon the state the burden of proving his guilt beyond a reasonable doubt. As I mentioned to you, Mr. Moorer has absolutely nothing to prove or disprove in this case. He certainly doesn't have to prove his innocence. In fact, in this country, persons accused of criminal offenses, such as Mr. Moorer, have what we call, and this term is used, and I want to tell you, when I use the word, they're not just words, the presumption of innocence. That's an active presumption that each one of you must maintain. And you must maintain it now, and can only be changed when, through your deliberative process, you're convinced beyond a reasonable doubt, that is firmly convinced, that the state has established each element required to change that position, in other words, to find that Mr. Moorer is guilty of the offense of kidnapping. Now, when a person accused, such as Mr. Moorer, is accused of a crime, they have nothing to prove or disprove. And in fact, a person so accused has the right to not testify. And that right is a very valid right and a very real right. And it applies to all persons accused of criminal offenses. And the fact that Mr. Moorer did not in this case testify may not be considered by you at any time. It may not even be discussed in the jury room. If it is, you will have violated the oath that you took, because you stated that you would look to the state to prove his guilt beyond a reasonable doubt. And that means that you have to assess the evidence and decide whether or not you're convinced to that standard or to that level. What is a reasonable doubt? A reasonable doubt is a doubt that would make an honest, conscientious juror who's searching for the truth in a case to hesitate to act or take some action. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Now, I would acknowledge that there are very few things in this world and in this life that we know with absolute certainty. And in criminal cases such as this, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that Mr. Moorer is guilty of this crime, then you must return a verdict of guilty. If, on the other hand, you think there is a real possibility that he's not guilty, then you must give him the benefit of that doubt and find him not guilty. A reasonable doubt, ladies and gentlemen, may arise from the evidence which is in a case, or the lack or absence of evidence in the case. And it's up to you to determine whether or not a reasonable doubt exists as to the guilt of this defendant. I charge you that he's entitled to every reasonable doubt arising in the whole case. And what do I mean by that? simply this: if upon any issue of fact, which is essential to a conviction and therefore a verdict of guilty, you should have a reasonable doubt as to how that is to be resolved, I would instruct you it is your duty to resolve that in his favor. Now, the evidence, of course, I've said throughout, consists of the testimony of the witnesses and exhibits that have been introduced. During the trial, and we've talked about this, the attorneys have made objections, and I've ruled that we've had matters of law and discussions out of your presence. And as I mentioned to you, it's very proper for them to raise those matters. And typically they were matters of evidence or involving the rules of evidence and the application of those rules. And you heard me many times make a ruling. The fact that they made the objection, the fact that I ruled on it, may not be considered by you, should not be considered by you. Because, as I stated, it is proper for them to raise it, and then it's my responsibility to rule on it. In fact, I told you that we work together to resolve this dispute. You and you alone have the duty of resolving the factual dispute. My responsibility is to resolve the legal dispute, or to provide the law. There's one situation that occurs from time to time. You've heard me say the objection, and I overruled the objection. I've simply said, as a matter of law, under the rules of evidence, I'm going to allow the witness to answer that question. Don't think that because I've ruled that it's allowable, that you now must accept it. Because if you did, then you've let me step into your area of responsibility. Quite simply this: I've said as a matter of law it's permitted, and that shifts to you. You have to decide whether you believe it or not, and if so, how strongly do you believe it? And that's how we work together. I'm giving you the law, and likewise, and we'll talk about this more in just a moment, you have to accept the law as I give it to you and apply it fairly and impartially to those facts. But not just as nothing the attorneys have said during the trial of this case can be considered evidence, nothing that I say should be considered evidence. Now, during their opening statements and their closing remarks, it is very proper for the attorneys to discuss with you the testimony of witnesses. It's proper for them to suggest reasonable inference. All that is very proper, and that's been done very ably in this case. But I would remind you that those remarks are merely to help you in analyzing the evidence and applying the law. They're not evidence. Their remarks, likewise, are not just as my remarks are not considered evidence. In fact, I would instruct you that if an attorney's statement of what a witness said or didn't say differs from your collective recollection of what that witness said, you're instructed to disregard the attorney's statement in its entirety. Why? Because you're the sole judge of the facts in this case. Also, if a statement of law differs by the attorney differs from the law that I give to you, again, you are instructed to disregard their remarks, because it's my job for today and for this trial to be the sole judge of the law. Now, how does one prove a case? How does the state present the case? They present it through presenting evidence. And evidence, there are two types of evidence: direct evidence and circumstantial evidence. And it's not uncommon to have both in a trial, sometimes one, sometimes the other, sometimes a combination. Direct evidence, as its name implies, generally deals with a sensory perception. I saw something, I felt something, I heard something, or the like. And if you're firmly convinced as to the truthfulness and reliability of that testimony, then that establishes that particular fact, circumstance. Circumstantial evidence is when you prove a number of facts and you're firmly convinced as to each of those facts, and you link them either by inductive or deductive reasoning, and it leads you to a very logical conclusion, and you're firmly convinced of that conclusion. It would establish that through circumstantial evidence. I would tell you that the Law makes absolutely no distinction between the weight or the value to be given to direct or circumstantial evidence, nor is there any greater degree of certainty required of circumstantial evidence than direct evidence. You're instructed to weigh all of the evidence and decide what you believe has been established beyond a reasonable doubt. But the law does say this: to the extent that the state relies on circumstantial evidence, it has to meet a certain test. First, as I mentioned to you, the state, as to each one of those events or circumstances that they are relying on, the state has to prove them beyond a reasonable doubt. Further, these facts must point conclusively to the guilt of the accused to the defendant, and they must be wholly perfectly consistent with each other in every particular respect. I would further instruct you, however, in that regard, that the mere fact that circumstances brought out in a case are strongly suspicious of guilt, or that circumstances are such that the defendant's guilt is probable, that would not be enough, because it has to be more than being suspicious of guilt to sustain a conviction, or more than somebody being probably guilty. It has to be proof that convinces you and satisfies you beyond a reasonable doubt. Now, generally, witnesses under our rules of evidence are not permitted to render opinions except in very limited areas. An exception to this rule is for witnesses who present themselves and we designate them or call them expert witness. And that rule simply provides that a witness who by education and experience has an expert in some art, science, profession, or calling, that person is permitted, or that witness is permitted to render an opinion as to relevant and material matters in which the witness claims that expertise. And that witness may also state the reason for the opinion. I would instruct you that you should consider any expert opinion received in evidence in this case the same as you would consider any other evidence, and give it the weight you think it is entitled. If you decide that the opinion of the expert is not based on sufficient education and experience, or if you conclude that the reasons given for the support of the opinions are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion in its entirety. An expert witness's testimony is given no greater weight than any other witness simply because they're expert, and they're not meant for the purpose of controlling your judgment. They really are meant to help you in analyzing the evidence in the case and deciding the true facts. I would further instruct you that you're not required to accept an expert's opinion even though it's not contradicted directly. Now, how do you decide the facts in the case? You do that through applying the exercise of your judgment, your sense of logic and reason and common sense. And I would instruct you that would be necessary to evaluate each witness, even when the testimony is not contradicted, as I've stated with the expert testimony, because why? Because as we know in our life, there would always remain the inherent probability, reasonableness, credibility of what one says. And you have to make those types of assessments. Now, there are many, many factors that we use in our life. You've done it many times. I'm going to discuss some of the factors with you now, but if I don't mention a method, a factor that you've used in your life that has assisted you in making this type of decision, please use it when you begin your deliberations if you found it to be reliable in your life's experience. But some of the things you may want to consider would be the appearance of the witness. How did they appear to you? Hesitant, straightforward in answering questions. Was the testimony of a witness consistent or inconsistent? Was it strengthened or weakened by other evidence in the case? How did the witness come to know the facts that he or she testified to, and what was the ability of that witness to know those particular facts and circumstances? Is there a reason for a witness to give testimony which may be helpful to one side or the other? In other words, was the witness biased or prejudiced in any fashion? In determining the credibility of witnesses and believability of witnesses, you're given very broad discretions. You have the right to believe many witnesses against one witness against many. You have the right to believe all of a witness's testimony, parts of a witness's testimony or none of the witness's testimony. Now, you don't make these decisions arbitrarily, but if there's a reason in the evidence and the record of this case for taking that position, you have that prerogative. Because your objective, your mission, so to speak, when you raised your hand on Monday, has been to determine the truth, regardless of the source of the evidence. Now, while you're given very wide latitude when it comes to determining the facts, please remember you don't enjoy the same with the law, because that falls into my area of responsibility. And you promise that you're going to accept this law and apply that law fairly and impartially to the facts that you determine. And if you hear a principle of law with which you differ, I respect your right to feel that way. If you hear a principle of law which you felt, well, I thought the law was such and such, or such and this and that, or whatever it is, you're entitled to think that too. But what you promise everyone here and to the court is that you'll set aside your personal feelings and take it as I give it to you and apply it fairly and impartially. And I'm confident you will do that. The order of my instruction means nothing. I had to put it in some order, and please consider the charge as a whole. Don't put any greater weight on any one aspect of it than you do on any other parts of it. And again, the fact that I instruct you on a particular issue is not to be taken by you as a suggestion as to how you to resolve that particular fact or circumstances. Let's look at the charge. The charge, as I mentioned, is kidnapping. And the state must prove, in order to obtain a conviction, prove beyond a reasonable doubt that the defendant knowingly and unlawfully seized, confined, inveigled, decoyed, kidnapped, abducted, or carried away another person without authority of law. To do a thing unlawfully is to do it willfully against the law. Knowingly means with knowledge, consciously, not accidentally. Seize means to take hold of suddenly or forcibly confine, means to limit, restrict, or enclose within bounds, imprison, or shut up, or keep in. Inveigle means to lure, entice, or lead astray by false representation, promise, or other deceitful means. Decoy means to lure by, or as if by decoy. A decoy is something to entice a person into a trap. Kidnap is to remove a person against his or her will by unlawful force or by fraud. Abduct means to carry off secretly or by force for an illegal purpose. Carry away means to remove. Now, the state does not have to prove that the defendant did all of these things. Instead, if you find beyond a reasonable doubt that Mr. Moorer did any of these things, you must find him guilty of kidnapping. Something done without authority of law is something which the law does not sanction, permit, allow, condone, or provide justification for. The kidnapping does not have to be for any personal or monetary gain, for any illegal purpose, or for any illegal purpose, but may be for any reason whatsoever. The gravamen of the offense of kidnapping is some form of compulsion, but the law says that the requisite force of compulsion need not consist of the use of actual physical force or violence or express threats. The offense of kidnapping commences when one is wrongfully and unlawfully deprived of his or her freedom and continues until the freedom is restored. Now, criminal intent is a necessary element of the crime of kidnapping, and that has to be established just as the elements of kidnapping beyond a reasonable doubt. Criminal intent is always a matter that's left to your determination, left to you to determine from the circumstances surrounding the situation. So the law states that criminal intent may be inferred from the circumstances which have been shown to have existed. Criminal intent is a state of mind that operates jointly with an act in the commission of a crime. Intent includes those consequences which represent the very purpose for which an act is done or are known to be substantially certain to result regardless of one's desire. Criminal intent is a mental state of a conscious wrongdoing. So it's up to you, ladies and gentlemen, to determine if you find the defendant committed this offense, what he intended to do based on the circumstances shown to have existed. I tell you, just as each element, they must prove that criminal intent beyond a reasonable doubt. Throughout this entire matter, ladies and gentlemen, you and I have been mined by the state, you by virtue of the oath you took, were selected. I selected by the Chief Justice and assigned, you selected by the parties, and to be a judge in this case. And as judges, we are called upon to do something which I've probably done this a little more than you have in being a judge. Something that's not difficult. I mean, it's not easy to do as a human being. It's very difficult. Because we're called upon to do something that's not, I'll confess, is not easy to do. And that's to set aside human emotion. Because if you think about it, it has no place in judgment. None. We've promised to set aside, notwithstanding all the emotion in this case, and in any case, but this case for sure. We can't be motivated by that. Because if we are, then we've really distorted what this process is about. It has no place in it. No, you were selected to be a fair and impartial individual, to apply your common sense, your sense of logic and reason, fairly and impartially, no friends to reward, no enemies to punish, to decide the true facts of the dispute, and then once deciding those, taking the law as I give it to you, have given it to you, and apply it fairly to those facts. And once you've done that, make your decision and report that decision. As presiding juror, to assist you in making the response, I prepared a verdict form which I'll be sending to you with the evidence in just a few moments. I'd like to discuss it with you now. You'll note that it's captioned, and the caption simply is to facilitate the filing. It means absolutely nothing. It's a formality. There are two choices, and the order in which they appear means absolutely nothing. I had to put them in some order. So you'll see that it reads as follows. We, the jury, by unanimous consent, what does that mean? It means all 12 of you. 12-0 has to be the vote. 11-1, not sufficient. It must be 12-0. Find the defendant, Sidney Sinclair Moore, on the charge of kidnapping. First choice, guilty. Second choice, not guilty. There's a line that precedes each choice. I'd like whichever the choice, whichever the jury agrees is a correct choice based on the evidence, simply put a check on the line, circle it, that we know it's yours, sign it where it says presiding juror, and you will have completed the form. What will you be saying if guilty is your choice? You'll be saying that you've analyzed the evidence and you're firmly convinced that the state has met its burden of proof and established each element of the crime of kidnapping beyond a reasonable doubt. And therefore, as I instructed, you must return a verdict of guilty. Not guilty means that collectively you're not firmly convinced of one or more elements, because if they fail on one, you must return a verdict of not guilty, because the state has to prove each element to the requisite standard. Once you've signed it, if you'll knock on the door, we'll be happy to return you to the courtroom and receive your verdict. I know you're anxious to get started, and you're almost there. Need to ask, of the first 12 that were selected, do any of you believe that you'll not be able to continue? Thank you. No hands are raised. Mr. Spencer, Ms. Thin. At this point, when the jury retires, I'm going to ask that you not rejoin them. They'll take you to another room, and I'll be in very shortly to discuss with you how much longer you need to remain. I know you want to get started, and you're there almost. Before I mention the final parts, you know, we've had a number of videos, and we have those available. We're not sending those back. If you need to hear any see any video, you just send me a note as to what you need. We'll queue it up and we'll bring you in and we'll let you watch it. If you have a dispute on testimony, please remember I told you, don't worry, just let me know who it is and we can replay that testimony for you as long as it's necessary to resolve any concerns you may have. As you've seen today too, there are times when you have to leave the courtroom for me to discuss certain things, and I have to now talk about my charge with the attorney, so I need to have you excused to accomplish that. It might be necessary to return you to the courtroom to give some clarification or some additional instruction, and if so, we'll do that and we'll bring the alternates back as well. But if there aren't any additions that need to be given, we'll gather the exhibits and deliver them to you. When you receive those exhibits, then you may commence your deliberations. Once the deliberations commence, the only restriction, Mr. Presiding Juror, that I place on the deliberations is this. If a juror has to leave the table for any reason, you must stop deliberating until all 12 of you are together. Otherwise, you proceed as you deem fit and proper. Thank you very much for your attention throughout this matter and your attention to my remarks. Retire to your jury room and await the exhibits before commencing your deliberations. Thank you. Exceptions, additions from the state?
No, Your Honor.
From the defendant?
No, Your Honor.
Thank you very much.
Thank you, Judge. We appreciate it.
Thank you.
It's a pleasure.
Thank you for your class. How you conducted yourself throughout this matter. And then that's sincere too. Yeah.
All those things like that, and all this stuff.
Now, I've done some research.